Remember when you were a kid and you disliked somebody so much, you didn't want them looking at you, talking to you, or allowing your name to pass through their lips? I remember even in kindergarten saying things like, "Don't look at me, don't talk to me." Well, imagine then what it must be like when your favorite musician of all time either dislikes you, disagrees with you, or just can't stand you to the point where they don't want you to play their music. What do? Well, to find out the answer to that question, let's look into the strange relationship between musicians and politicians, specifically Neil Young and Donald J. Trump.
There's someone you should know.
Hey everybody, welcome to the BOMB Podcast. BOMB stands for Business of Music Bootcamp, which means that this is the place where we will drill down on the business and legal aspects of the music industry. Everything from copyrights and contracts to policies and practices. Whatever it takes to educate and empower you with the knowledge you need to make informed decisions about how to protect yourself and your music is what you'll find on the BOMB. I'm your host, Professor Butler, and as a retired entertainment attorney, former record label executive, music law professor, and college administrator, I have counseled thousands of artists and musicians on the intricacies of the music business. Now it's your turn.
The information in this podcast is not intended, nor should it be construed as legal advice. If you have questions of a legal nature, we strongly recommend that you contact an attorney in your local jurisdiction who specializes in music and/or entertainment law. For guidance, check out our website at professorbutler.com and sign up to receive a free resource on how to find the right lawyer for you. And now, your host of the BOMB Podcast, Professor Butler.
Hey everybody, welcome to the BOMB Podcast, episode number 7. I'm your host, Professor Butler, and in this week's episode, we will dive into the question of who can use or perform your music and for what purposes, with or without your permission. This subject is a pretty big deal, which is why I will try to break it down as best as I can. But the core issue involves one of your exclusive copyrights, known as the exclusive right of public performance, which in a nutshell means that no one can perform your music in public without your permission. Now, most of you have already given that permission as songwriters through your performance rights organization, also known as your PRO, which we'll talk about in just a minute. But first, I want to tell you a story. You know how much I like starting off with a story or a letter or an email I got. But this story is what prompted this week's episode in the first place. It has everything to do with a classic rock musician by the name of Neil Young and his dispute with the current president of the United States, Donald J. Trump. Now, you remember when you were a kid and you disliked somebody so much that you didn't want them looking at you, talking about you, or allowing your name to pass through their lips? I remember even in kindergarten saying things like, "Don't look at me," or "Don't talk to me." Well, imagine what it must be like when your favorite musician of all time either dislikes you, disagrees with you, or just can't stand you to the point where they don't want you to play their music. What do? Well, to find out the answer to that question, let's look into the strange relationship between musicians and politicians, specifically Neil Young and Donald Trump. In June of 2015, Donald Trump held a rally at Trump Tower, announcing his bid for the presidency. During that rally, his campaign played the song Rockin' in the Free World, which was co-written by a celebrated Canadian-American, Grammy-winning, two-time Rock and Roll Hall of Fame inductee, singer, songwriter, and activist by the name of Neil Young. According to a 2015 article in Rolling Stone entitled Neil Young, Donald Trump Spar over Rockin' in the Free World Use, which I posted a link to in the show notes, when the song was first released in 1989 off of Young's Freedom album, the song Rockin' in the Free World quickly became a rallying cry in post-Reagan America for American values and for the fall of communism. Young criticized then President George H.W. Bush's ideology and even blasted Republicans for what he felt was a disregard toward the lower class. So Neil Young's liberal political leanings have been well publicized over the years. So 25 years after the song is released, Republican candidate Donald Trump comes along and either without knowing or without caring about Young's political stances, decides to use Rockin' in the Free World as his candidacy announcement, after which Young immediately speaks out, saying that Donald Trump was not authorized to use Rockin' in the Free World in his presidential candidacy announcement, and that Young, a Canadian citizen, was a supporter of Bernie Sanders for president. When asked about it, the Trump campaign said they paid for and obtained a license to use the song from ASCAP, Young's PRO. They even went on to say that Trump is a huge fan of Neil Young and his music and will continue to be regardless of Neil's political views. However, as a result of Young's protest, Trump's campaign manager said, and I quote, "We won't be using the song again. There are plenty of other songs to choose from, despite the fact that Mr. Trump is a big fan and likes Neil very much. We will respect his wish and not use it because it's the right thing to do." Close quote. Young was satisfied and even later said that he doesn't harbor any resentment towards Trump for using the song, that he had nothing against him, and that he might have even okayed the usage if Trump had just asked his permission first. So all of this happens 5 years ago. Trump campaign stops using the song. Bernie Sanders campaign starts using the song with Neil Young's permission. And all is well, right? Wrong. Because here we are 5 years later, same artist, Neil Young, same song, Rockin' in the Free World, plus one more song, same politician, Donald Trump, and the same old issue, which is public performance, aka, I don't like you, so stop using my music. Before we talk about who has the upper hand in this dispute, let's talk about what's at the center of the issue for all musicians, and it's your exclusive rights as a musician. When you secure a copyright in either a sound recording or in this case, a musical work, right, a song or a composition, you automatically receive 6 exclusive rights, which basically means that no one can do any of these 6 things without your permission. And because copyright protection is automatic upon fixation, which I discussed in detail in a previous episode, whether you write the song down on a piece of paper or record it on your computer, you are automatically entitled to these rights. The 6 exclusive rights are the right to reproduce, the right to distribute, the right to make derivatives, the right to publicly perform, the right to publicly display, and the right to publicly perform sound recordings via digital audio transmission. Now, I may have to do 6 entire episodes on each of the exclusive rights, only as they pertain to musical works and not the other categories of copyrightable works, right? Because there are so many rules and so many exceptions to each rule. But for now, let's just do a quick overview of each exclusive right, and then we'll drill down on the one at issue. The right to reproduce means that no one can reproduce, copy, or record your music without your permission. And of course, there are exceptions, such as the mechanical and the compulsory mechanical license, but we'll have to talk more about that at another time. Second, the right to distribute, which means that no one can rent, lease, sell, or even give away your music. without your permission. Then there's the right to make derivatives, which means that no one can edit, alter, change, adapt, or rearrange your music without your permission. The right to publicly display means that no one can show or display your music in public without your permission. Usually that would be like lyrics or musical notes on a poster or a book or a magazine. And the right to publicly perform, which means that no one can perform your music in public without your permission. Finally, the right to publicly perform sound recordings in public via digital audio transmission in public without your permission. Now, that last one, the one about the sound recordings and digital audio transmissions, can be a little complicated, so I promise to cover it in a future episode. But for today, let's just focus on the right to publicly perform your song, your composition, or other musical work. The public performance right really depends first on what we mean by the word public. Public means a few things, including any place open to the public, any place where the music is being transmitted by device to the public, whether the public is there or not, or any large gathering of people who are not family and friends. So, other words, when we talk about public performance, we're talking about performance of your music in a place that's open to the public, that's transmitted to the public, or where there's a large gathering of people who are not family or friends. So you can play Neil Young's music at your backyard barbecue, your wedding, your family reunion, or other private gathering, all you want. But as soon as that gathering exceeds family and friends and becomes open to the public, it becomes a public performance, which requires permission of the copyright owner of the song or the composition, which is usually either the songwriter, the songwriter's publisher, or both. Now, here's the tricky part. When you want to perform one of Neil Young's songs, let's say on stage at your next gig at the local pub or club in front of 50 to 100 or so people who are not family and friends, that's a public performance. We get that. But you personally do not have to get Neil Young or his publisher's permission to sing the song. What do I mean by that? Well, a minute ago, I just said, if you're going to perform somebody's song in public, you got to get permission. And now I'm telling you that you don't have to get permission. What I said was you personally do not have to get permission. Why not? Because you are not the performer. Or should I say you're not the one publicly performing the music. So what do I mean by that? Okay, follow me. The performer has to get permission to perform the music in public. The performer who has to get the permission is not the person or the person standing on the stage. The performer for copyright purposes is the person or entity that makes the performance available to the public and thus benefits the most from the use of the music. In other words, it's the venue that opens its doors to let people in that is making the performance available to the public, and thus is the one who has to get the permission to perform the music. You can sit on that stage all day and all night and sing your little heart out till your face turns blue. But if that pub or that club doesn't open its doors to let people in, you'll be singing to yourself. That's why it's the venue that has to get permission to perform the song. And in this case, the Neil Young song, not the person singing. Now, I know what you're thinking. Does every club have to ask Neil Young for permission to sing or perform their song, right? Or does every club have to get permission from every single songwriter whose songs they want to play or perform in order to legally play or perform their music? And the answer to that is no, of course not. Every songwriter that wants to receive royalties for the public performance of their music must join a PRO, sign an agreement with a PRO, and then transfer their right to publicly perform or give permission to publicly perform to the PRO. PRO stands for Performance Rights Organizations. And PRO's mission is to protect its members' musical copyrights by monitoring and keeping track of public performances of their music, whether it's via broadcast performance or live performance, and then compensating the songwriter accordingly. In other words, if you want to get paid every time your music is performed, either on the radio, on TV, online, in the supermarket, at the club, at the hotel, on the elevator, whether you're on hold, wherever your music is performed in public, if you want to get paid as a songwriter, you must belong to a PRO. And when should you join a PRO? Now, people differ on this one, but let's just take it from a common sense perspective. As soon as you have music that is or is about to be performed in public, that's when you join a PRO. Because once you're a member, you'll inform your PRO through their registration process of which songs you wrote and the fact that those songs are about to or are already being performed in public, and that the PRO needs to start keeping track of how many songs or how many times your songs are being played. This is one reason why you should make your PRO your best friend, especially if you're performing live in small venues across the country. You want to make sure that you're getting paid every time your work is performed in public, and having a good relationship and a consistent relationship with your PRO is one way to do that. Now, every country has its own PRO, but there are several of them just here in the United States, including 3 of the most popular, which are ASCAP, the American Society of Composers, Authors, and Publishers, BMI, Broadcast Music Incorporated, and CSAC, the Society of European Stage Authors and Composers. You can only join one at a time. So the fact that there's 3, 4, 5 of them here in the United States only means that you have more choice. If your music is performed outside of the United States, you don't have to worry, because all of the PROs have something called reciprocity around the world, which means the PRO in the other country would collect your royalties for you and would forward them to your American PRO to make sure you get paid wherever your music shows up. So let's say you're playing a gig, and the club or the venue, whether it be an arena, a stadium, a TV network, radio station, whatever, they have to apply for what's known as a blanket performance license from each of the PROs. That's the only way that they're going to be covered for every song that could possibly be played in that club. The blanket license allows the venue to perform any and all of the songs in the PRO's catalog. That way, you don't necessarily have to keep track of which songs are going to be performed, because any song that you might perform is covered by the blanket license, which is why they call it a blanket. Any entity that publicly performs music has to pay a licensing fee to the PRO. The license is the PRO's way of giving the venue permission to play its members' music. The fee that each venue pays to the PRO will depend on a number of things, including the size of the venue, the capacity or the size of the audience, the amount of music it plays, how much money it brings in annually, any number of things. Therefore, a small coffee shop that plays music for a few hundred customers will pay a far less licensing fee than a major TV network with millions of viewers. And the licensing fees are what are used to pay the songwriters. So the PROs are really, really good about making sure that if anybody's performing music publicly, that they get a license from that person or entity. And how do they know how much money to pay which songwriter? Well, it really depends on when, where, and how the music is performed. Whether the music is played early in the morning, when everybody's asleep, like 2 o'clock in the morning, versus whether the music is being played during rush hour, when everyone's in their car, headed home, right? One usage, the rush hour usage, will generate more income than the 2 a.m. usage. And the way the PROs determine which songs are played depends on the outlet. For example, TV shows and production companies create what are known as cue sheets that indicate exactly what song was played, when it was played, and how long it was played for. So anytime your song is on a TV show or in a TV commercial, you are definitely going to get paid because they really keep track of exactly what songs they're using. Now, when it comes to live venues, they will have the artists submit a set list so that they can track the songs being performed live in concert. And for radio, the PROs usually identify a random sampling of a number of different radio stations of various sizes and types across the country, or they secure the on-air playlist or broadcast logs from that sample to determine which songs are frequently being played on the radio station. And trust me, if I could explain to you exactly how the PROs calculate this revenue and keep track of the millions, even billions of songs and times the songs are being played, trust me, I would explain it, but I have no idea. They use a really complicated formula that nobody I know understands, but as far as I know, no one questions. So with all that said, 2015, when candidate Trump used Neil Young's Rockin' in the Free World at his campaign rally, Neil Young was a member of ASCAP, and had Trump been just an ordinary citizen throwing a party at Trump Tower, a private party, or even a public party, right? Either the Trump Tower would have had a license, or the party promoter who was throwing the party, right, would need to have acquired a blanket license from ASCAP to perform any song in the ASCAP catalog, which would have included Neil Young's Rockin' in the Free World. Apparently, back then, that's exactly what they did. But Neil Young still protested the use of his music for a campaign that he did not believe in and a candidate that he did not support, so the campaign stopped using the song. However, today, Trump is not just an ordinary citizen, and the party at Trump Tower was no ordinary event. Different rules apply to politicians and campaign events, public performance of musical works, so much so that the PROs have created their own rules and regulations in their contracts regarding public performance. ASCAP has even created a great circular called Using Music in Political Campaigns, which is available on their website. And I posted a link to the PDF of the circular in the show notes, which you can get at professorbutler.com. So according to ASCAP, while many venues have public performance licenses from ASCAP, as well as the other PROs, political campaigns cannot rely on existing venue licenses because those licenses generally exclude music that's going to be used during either a convention, an exposition, or a campaign event. If a campaign is holding several events at dozens of different venues, right? The PRO won't usually require that they get a license for each and every venue. What they do is the campaign will obtain a political campaign public performance license from the PRO, and then that license will allow them to go on the road, meaning the political campaign license is issued to an individual candidate's specific campaign and extends only until the candidate is sworn into office, not for the candidate's full term in office. Having such licenses in place would guarantee that no matter where you go on the campaign trail, the performance of music at the event would be in compliance with copyright law. So in other words, if you're a campaign or if you are a politician, you get a political campaign license, which allows you to perform music from that PRO's catalog anytime during your campaign. But the extent or the scope of that license stops once you get sworn into office. However, the political campaign license agreement, although it provides a blanket license to perform any or all of the millions of compositions, in this case in the ASCAP catalog, individual members may ask the PRO to exclude specific songs from a particular political campaign license. In that event, ASCAP or the PRO will notify the campaign of the excluded works and presumably tell them that they can't use the song that they want. So even if a campaign gets a political public performance campaign license, right? Individual members of ASCAP, which are basically just the songwriters, can say, if you issue such a license, I do not want you to include my songs. So let's say in 2020 that Donald Trump got such a political campaign license from ASCAP. If Neil Young's song, Rockin' in the Free World, was excluded from that license, then the campaign's use of that song is considered copyright infringement. That's what I believe happened in the current Neil Young versus Donald Trump case. Either the Trump campaign failed to get a license in the first place, which would have been stupid, right? Because the campaign knew how Neil Young felt about the Trump campaign as early as 2015, 5 years ago. It's either that or they did get the license, right? They actually even got a political campaign public performance license, but they didn't know or didn't care that Young's song was not included in that license. That's exactly what I believe happened. I'm sure that after that last fiasco with Donald Trump, that Neil Young made sure to let ASCAP know that he did not want Trump playing his music at Trump's campaign events. That's why Neil Young is suing the campaign for copyright infringement, which basically means that the Trump campaign used not just one song, but two songs, Rockin' in the Free World and Devil's Sidewalk, at their rallies without proper permission, because those songs were not part of the permissions that they may or may not have received, hence violating Neil Young's exclusive right to public performance. Phew! And as an update, as of the date of this podcast, a federal court judge was assigned and a civil lawsuit summons was issued in U.S. District Court. In a statement from Neil Young's attorneys, they say that the plaintiff, which is Neil Young, in good conscience, cannot allow his music to be used as a theme song for a divisive, un-American campaign of ignorance and hate. And that, quote, the campaign does not now have, and did not at the time of the Tulsa, Oklahoma rally have, a license or plaintiff's permission to play the two songs at the public political event. Therefore, Neil Young is seeking a court order barring the Trump campaign for playing any of his songs, as well as damages of between $750 up to $150,000 for each infringement. The money, the $750 up to $150,000 that Young is asking for, is referred to as statutory damages. A plaintiff in a lawsuit can opt to receive statutory damages when they either do not know or cannot calculate what the actual damage or lost profits are. And all of this is at the discretion of the judge. Statutory damages between $750 and $150,000 per infringement means that every single time each of those songs were played, the judge can award anything between those two amounts, and they can even go beyond those amounts, either lower or higher if they decide to, because it's up to their discretion. For example, if the infringement was what we call innocent infringement, meaning that the infringing party didn't know or had no way of knowing that they were infringing upon somebody's exclusive rights, the statutory damages might be as low as $750 or even lower than that, depending on the circumstances of the case. It's all up to the judge. If, however, the judge finds that there was willful or intentional infringement, meaning the defendant knew darn well what they were doing, then that's when the judge has the right to issue damages at the highest amount, $150,000 per every time that song was played, and even higher than that if the judge decides to award punitive damages in order to make an example of or punish the infringer. Not only might the campaign be liable for copyright infringement, though. They might also be liable for a whole host of other claims, legal claims. According to the ASCAP circular, even if the campaign has the proper performance licenses and there were no exclusions, the campaign could still be in violation of other laws based on the artist or the songwriter's right of publicity, which means that no one can use their name or likeness for commercial gain without their permission. Right of publicity exists in many states to provide image protection for famous people, and actually for you too in some circumstances. They could be in violation of the Lanham Act, which covers the unauthorized use of someone's name, logo, or other identifying trademark, causing trademark confusion or dilution. The campaign could also be sued for false endorsement, where use of the artist's identity or their music implies that the artist supports a product or a candidate when they really don't. ASCAP basically said that as a general rule, a campaign should be aware that in most cases, the more closely a song is tied to the image or message of the campaign, the more likely it is that the recording artist or the songwriter of the song could object to the song's usage by the campaign. And if that campaign really wants to eliminate any of these claims, particularly if they want to use a song as a theme song, right? They should contact the artist manager, the record label, songwriter, and or the publisher to obtain their express permission to use the song of their choice. Phew, there goes another one. So what have we learned today? Well, first of all, we learned that there are 6 exclusive copyrights: right to reproduce, right to distribute, right to make derivatives, right to publicly perform, right to publicly display, and the right to publicly perform sound recordings via digital audio transmission. We learned that the right to publicly perform means that no one can perform your music in public, and we defined public, without your permission, which generally comes through your membership with your PRO. We also learned that you can carve out in your agreement with your PRO the use of your music in conventions, exhibitions, or political campaigns that do not align with your values or your political perspective. And we learned that in the event that someone that you don't like or disagree with has a valid license, you still may be able to take action against them, performing your music through the use of your right of publicity, your trademark rights under the Lanham Act, or false endorsement. All right, that concludes this episode. And you notice how happy I am whenever we conclude an episode, because this is a lot of work. But it's so much fun. I hope you enjoyed this week's topic and tune in for another week of education, empowerment, and fun with the Bomb Podcast. I'll see you soon. Thanks for joining me on the Bomb Podcast. If you were educated, empowered, or inspired by what you heard, please subscribe today to be the first to receive the latest episode. And don't forget, post a review, tell a friend, follow me on social media, and join my tribe at ProfessorButler.com.